And we are here, my notes say we're here on a motion for summary judgment. Is that correct, or is it something else?
No, Your Honor. As far as I know, two of my motions are noticed for hearing today. It's my motion for leave to conduct limited discovery and my motion to strike affirmative defenses.
Okay. Counsel, is that your understanding?
Yes, Your Honor.
Okay, I'd gone through a bunch of cases. Okay, so we've got a motion for discovery and a motion to strike affirmative defenses. Let's take up the affirmative defenses issues first.
Before I argue either, Your Honor, may I take 60 seconds to say where the case stands?
Sure.
So defendant's April 20 supplemental response calls this, quote, a $345 breach of contract case for a damaged suitcase. And then defendant's April 28 reply repeats that framing, calling plaintiff's recovery of $345 the only triable issue. But the supplemented record now before the court, the declaration and exhibits A1 through A7.
The hearing begins with the judge confirming the purpose of the session. Initially, it appears to be a motion for summary judgment, but it is quickly clarified that two motions are actually on the table: a motion for leave to conduct limited discovery and a motion to strike affirmative defenses. Both sides confirm the issues, and the judge decides to address the affirmative defenses first, setting the tone for a structured legal debate.
I filed last Wednesday, tell a different story. Delta took a hardshell carry-on bag at the jetway after I asked the agent on video for assurances of careful handling, telling him there were cameras inside, and the agent answered yes, sir. Then Delta returned the bag to me at Austin with the shell punctured and the drone inside crushed, while other electronics packed inches away in the same bag weren't damaged. So the record is what I asked the court to keep in mind as I argue both motions today.
Okay. All right. And they're your motions. You can go ahead and let's do it.
Okay, so my motion to strike does two things, Your Honor. First, it asks the court to apply Rule 91 special exceptions to Delta's boilerplate affirmative defenses. Defenses that, as pleaded, do not give me fair notice of what Delta is actually putting at issue. And second, paragraph 17 of Delta's answer asserts the contract of carriage limitation.
Before arguments begin, the plaintiff's side requests a brief moment to outline the case background. They argue that the defendant has repeatedly reduced the dispute to a simple $345 damaged suitcase claim. However, the plaintiff insists the reality is far more serious. They describe how a checked bag was allegedly mishandled, resulting in significant damage to a drone and other electronics inside.
And I ask the court to find the defense legally insufficient as drafted because it cannot disclaim duties Delta owes independent of the contract. So there are a few things that were in defendant's reply. So Delta's December 1st response makes three procedural objections, and I want to address each of them candidly. First, Delta says Rule 90 doesn't independently grant relief. That's correct. I cited Rule 90 to preserve error, not as a vehicle, so I withdraw my reliance on Rule 90 as the basis for relief. And secondly, Delta says Rule 91 only dismisses cause of action, not affirmative defenses. That's correct as well. I would withdraw that as well. The third one, Delta cites James versus Underwood and Miranda for the proposition that defendants have no burden to plead facts in support of affirmative defenses. And with respect to Your Honor, both cases are about jurisdictional pleas.
The plaintiff continues, explaining that the bag was handed over at the jetway with assurances from airline staff that it would be handled carefully. However, when the bag was returned, it had visible damage, including a punctured hard shell. Inside, a drone had been crushed, while other electronics remained untouched. This contrast, they argue, raises serious questions about how the baggage was handled.
Miranda is sovereign immunity and James is judicial immunity, and neither case holds that ordinary Texas Rule of Civil Procedure 94 affirmative defenses are exempt from the fair notice. And the Texas Rule of Civil Procedures 91's own text applicable to any pleading. So it makes it clear that the special exceptions are the proper vehicle here.
Counsel response?
Like you said at the end, special exceptions are meant to launch a argument, not to provide actual affirmative relief. If that were the case, then every plaintiff after the defendant answers could be able to file special exceptions and immediately strike. He has fair notice. I mean, he was able to name each of our affirmative defenses that he wants to have stricken. So in terms of it being a fair notice rule, he had fair notice. It's a not substantive rule where affirmative defenses can be struck. And it is based off of causes of action.
The plaintiff formally argues the motion to strike. They claim the defendant's affirmative defenses are vague and fail to provide fair notice of what is actually being contested. They also challenge the legal validity of the contract of carriage limitation, arguing it cannot be used to avoid responsibilities that exist independently of the contract.
Those rules that he cites, 90, 91, and 91A, are all meant to provide for a vehicle of special accepting and dismissing or striking a plaintiff's causes of action, non-affirmative defenses for a defendant. At some level, an affirmative defense does not require a pleading burden. It just requires fair notice, which he had. So even if the court were to want to grant substantive relief, it has already been given to him because he has notice. In other words, it would be different if we had just pled only a general denial and he doesn't know what issues we're going to bring up at trial, but he has all those issues in our pleading.
Okay, I'm going to deny the motions to strike. Let's go to the motions for discovery. Have y'all exchanged? Is there any discovery going on? Any informal?
Yes, Your Honor.
The defense responds firmly. They argue that the plaintiff is misusing procedural rules, stating that special exceptions are not meant to provide direct relief or strike defenses in this way. They also insist that their affirmative defenses already meet the legal requirement of fair notice, since the plaintiff clearly understands the issues being raised.
I submitted, there was a discovery approved from Delta that I submitted responses for back in February.
So what discovery issues are we here on today?
So I wanted to ask the court the leave to serve 8 interrogatories and 10 requests for production on Delta. 3 months ago, court granted Delta's motion to take discovery from me, and I have since responded, verified responses with a video, a transcript, photos, and receipts. I now seek narrow reciprocal discovery on facts that are uniquely within Delta's possession.
In your motion, did you set out the discovery?
I'm sorry?
In the motion for discovery, did you set out the specific discovery?
Yes, so in its February 19 response, Delta agreed to produce the contract of carriage and related documents, agreed to produce non-privileged material responsive to requests 1, 2, 4, and 5, and agreed to answer interrogatories 2, 3, 5, and 6.
The defense further argues that affirmative defenses do not require detailed factual pleading, only fair notice. Since the plaintiff is already aware of the defenses listed, they claim there is no legal basis to strike them. The judge listens carefully as both sides present opposing interpretations of procedural rules.
I do appreciate that, and I would ask the court to confirm the production on those items, and then we can address the disputed ones one by one.
Why don't you just tell me, go through the disputed ones and tell me where we are.
So the RFPs 3 and 9 and interrogatory 4, it's baggage tracking records. These are the records that show what happened to the bag once Delta took it. So bag tag number, scan location, scan timestamps, irregularity or damage codes. Delta has them, every airline has them. They're how a carrier finds a missing bag. So then it's RFP 6 and 7, which are...
Let's go back again.
Okay.
Interrogatories, what numbers?
Interrogatory 4 and RFP 3 and 9 are relating to the baggage tracking records.
4, 3, and 9?
After hearing arguments, the judge rules against the motion to strike affirmative defenses. The court finds no sufficient reason to remove them at this stage, effectively allowing the defense's claims to remain in the case.
Yes, interrogatory 4, but our request for production 3 and 9.
Oh, okay. Let's do them one at a time. Interrogatory 4, what's the issue here?
So they all stem from the same thing. They're the records of how Delta handled my bag. And I want to see if there are any irregularities. So there was a big puncture in the case. So if there was mishandling or maybe issues with equipment, I think this will help pinpoint exactly what happened. Because the damage that happened to the bag was not from careful, ordinary handling. The hard shell was punctured, so it points that something is wrong there, and I think the baggage tracking records will help us figure it out.
Counsel?
The court then shifts to the motion for discovery. The plaintiff explains that they are seeking limited but targeted discovery from the airline. They highlight that the airline had already been granted discovery rights earlier, and now reciprocal information is needed to move the case forward fairly.
That is something that could be interesting to learn. It's just not an issue for trial. I mean, the fact is he had the bag, he got the bag, it being punctured, so what happened in the middle isn't relevant. It's only going to paint a prejudicial picture about who, what, when, the handling. And like he said, the handling records go to missing bags, and this is not a missing bag case. So if we had lost his bag, then these documents, this information would be relevant for trial, because we do need to get to the bottom of how, if there was actually negligence or if it was just a simple technological error. But this is not one of those. It's simple that he had it, it got checked, he got it and was punctured. So that's what we would say. Those are relevant for missing bag cases. This is not one of those.
I'm gonna approve the discovery. If there are any documents or records on that, I want them produced.
The plaintiff requests specific internal records, including baggage tracking data, system logs, and handling records that could explain what happened to the suitcase. The defense argues these records are irrelevant, claiming the case is simple since the bag was returned damaged and not lost. Despite objections, the judge begins granting several discovery requests.